You are on bond for murder, and you've now picked up an assault case.
Okay, wait a minute, you're out on bond for murder. Yes, murder. And now you're adding an assault charge to the mix? Yikes. You can practically hear the judge's frustration already. But what's going on here? Was she just ... having a bad day, or is there more to this than meets the eye?
You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
Thank you, Your Honor. On April 27th, 2025, in Harris County, Texas, officers were dispatched to a disturbance/unknown weapon call. The complaining witness stated she is part of the nursing staff and that the defendant has been asked to leave on multiple occasions and refuses to do so. The complaining witness stated that the defendant was attempting to get her grandfather to sign over power of attorney to her, but the staff would not allow this due to the grandfather being diagnosed with dementia. The complaining witness stated that the defendant used force on the complaining witness to get her to leave the grandfather's room. The complaining witness states that the defendant put her hands on the complaining witness's face and pushed it back. The defendant was positively identified by the complaining witness and her Texas ID number.
You say that there was any pain? She pushed in the...
The classic move a last-minute defense lawyer. Honestly, it's always a little suspicious when a defense attorney just appears out of nowhere. Is this an expert or just someone who got handed this case because, well, it's a high-stakes one? Spoiler alert, I'm guessing the stakes are about to get even higher.
face. This is an assault, right? There has to be some kind of injury or pain.
She did state that she felt pain in the dim summary.
Okay. Ms. Taylor, I'm going to find that there's sufficient probable cause to go forward with the case. Now, you're saying there's a bond violation in this case?
Yes, Judge, it's in the...
Michael, have you seen this? And how did you already get appointed to this case?
Your Honor, I was appointed sometime very recently on this case. I received a text. I don't know what day it was, but I received
It looks like it was the 29th, which was Tuesday. But how was he appointed a lawyer?
I'm thinking when she was in the holdover.
No. How is she, I mean, I don't understand. Well, regardless, I guess I'm glad that you're appointed because right now she's got bond violations. She was ordered by the magistrate.
I wasn't aware of that, Judge.
I'm sorry?
I wasn't aware of a BVR in this case. I actually have another BVR today before the court.
I know that. Yeah, we got you. We'll deal with that one next, but you're on bond for murder. You were ordered by the magistrate to have a GPS monitor. You have violated those conditions. Unacceptable. I'm revoking your bond. She goes with you. No.
Your Honor, if I may.
Yeah.
Your Honor, she just was released.
Okay, let's break this down. She was just released from jail, right? And then, boom, bond violation. And the judge is like, nope, you had one job and you blew it. You ever just wonder how people manage to get out on bail and then do something so, well, dumb?
Because I met her in the holdover earlier this week, and she could not have been out of jail more than a day, two at the most. Would the court allow her to leave right now to get the device?
No. Did she not get the device?
Judge, there was a conflict, that's why the DVR was submitted, felony, so the magistrate ordered bond conditions, but the curfew times were not aligning with the felony condition.
So what? I mean, you still have to abide by the conditions. I mean, what did they say the conditions were?
I have the paper up right there.
I'm not asking you to say anything, Ms. Taylor. The only thing I want is I want my city protected. You're on bond for this serious case, and now you picked up an assault. I mean, you were ordered to have certain conditions. You must abide by these conditions.
And Your Honor,
She received conditions of bond on April 28, 2025 that ordered a GPS device with a curfew of 7 p.m. to 7 a.m. On May 1st, she had an unapproved enter at 7:52 p.m. and then left again at 8:51 until basically 9 o'clock at night.
Yes, Judge, and on the felony conditions, I'm looking at them right now, curfew is from 12 a.m. to 6 a.m. So that's where it's conflicting. So the magistrate ordered from 7 p.m. to 7 a.m. and on felony, their curfew was 12 a.m. to 6 a.m.
I mean, she still has to follow conditions, right? There may be conflicting, but you abide by the conditions and then you come to court and you ask to, do something or maybe make them align, but you just don't do whatever you want to do and think, okay, nothing's going to happen. You're on bond for 2 serious cases.
Case, same old problems. And here comes that classic moment when a defendant starts getting super defensive and says, but I was never a danger. I mean, if you weren't a danger, why are we still talking about curfews, GPS ankle monitors, and staying away from certain people, huh?
Your Honor, if I may again,
Sure.
this is a brand new case. Could the court admonish her? Because the amount of time, I understand that.
Michael, she's on bond for murder. She's lucky to even have a bond, and now she picks up an assault. She's ordered to have a curfew, and she's just doing whatever the hell she wants to do.
In this case, Judge, that's before your court. This is a brand new case, and this is her first time having any issues while on your bond, Judge. Would the court be willing to admonish her not to leave her home even for short periods of time?
I don't know, Michael. I don't know.
And my assumption is we're going to reach out to Melanie. My assumption is there's a DVR call for that too. So I don't know what to comment or like, but.
I don't know, Michael. I'm going to stew on it for a while. You
Yes,
want to
Your
talk
Honor.
about your other BVR? Or wait, hold on a second. Sorry, let me just finish with the arraignments. Give me 2 seconds and then we're almost
No
done.
problem, Judge.
Good morning, Mr. Randolph. So you're charged with assault, causing bodily injury. You're facing up to a year in jail and our $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. All right.
The judge. Judge on.
We're doing here. There's no reason for you to be looking out there. We're going to do probable cause. We have to find out what happened with the case.
Judge, on April 23rd, 2025, an officer dispatched an assault call and made contact with the complaining witness, and the defendant. The complaining witness stated that he saw the defendant talking to and following a witness, and the witness then started to run away, and observed the defendant to chase after the witness. The complaining witness then got in between the defendant and the complaining witness, and the defendant then struck the complaining witness with a closed fist. The complaining witness said he felt pain and then grabbed the defendant, and they proceeded to grapple until security arrived. The witness stated that she did not know the defendant and that her and her friend walked past the defendant on the street. The defendant then began to verbally harass them and started to get verbally aggressive. She asked the defendant to leave them alone, and the defendant continued to refuse to do so, and that she began to walk away and to try and get away from the defendant, but got stuck at the intersection crosswalk. Then corroborated the facts that the complaining witness provided about getting in between the two of them.
Mr. Randolph, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. Do you understand? I'm ordering you also now not to be in possession of weapons, not to have any contact with the complaining witness, and not to go to this part of the street. Do you understand?
Yeah.
Don't be a danger to my city, man.
Hold up. He's literally talking about protecting the streets from these people. The irony here? The only person he's a danger to is himself. But it's like that classic I'm the good guy, everyone else is the problem move, right? What's the real deal here?
I'm not asking for much.
I'm not in danger. I didn't never know these people, Your Honor. I was out.
Don't.
I need a public defender.
I'll give you one. But I'm telling you now, Mr. Randolph, don't be a danger to my city.
I was never in danger. Just I don't intend to be in danger either.
All I want my streets safe.
It
And
was in danger to me, and that's why I'm showing up today.
I'm going to protect my streets at all costs. You
Can you
understand?
protect me from these kind of people?
I'm going to have you go to Victoria, sign a reset. After that, I'm
I
going
do
to
need a public defending office, your judge or
I already
lawyer.
told you I was going to give you one. Just really.
I'm really scared for my life because I just did 4 years and I'm going through the same thing again in your courtroom when I did good and I'm going through all the facilities. There was never in a harm's way standing 100 feet away from these people or 200 feet. I was never 100 feet within there.
Oh, exercise.
And I'm
the right
running from
to
these
stop.
people.
You're going to say something that hurts your case. Just stop.
Yes, sir.
I'm not asking you to say anything. I just want,
I just want to also be safe in your community also.
don't use any dope. Don't use any alcohol.
Never was. I was sober that day. I was sober as can be, no drugs, nothing. Enjoying a beautiful day for my mama's funeral. I know no rules. I don't know these people.
Listen, just I'm going to have you sign a reset. I'm going to have you take your seat in the jury. Yo, I'm not done talking to you. Once you sign the reset, just take a seat in the jury box. I'm going to find your lawyer, but we need you to sign conditions. Don't leave until you sign the bond conditions.
Yeah.
Come on. You are on bond for criminal mischief. You've now picked up a new case. You now stand charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
The judge. On April 26, 2025, a law enforcement officer is on patrol and observed a motor vehicle run a red light and make a U-turn, nearly striking another vehicle in Harris County, Texas. Law enforcement officer observed the motor vehicle drive onto the curb of Richmond Avenue and initiated a traffic stop. The defendant passed multiple open parking lots and continued to drive. The defendant eventually pulled into a business parking.
Ah, here we go, D. I charge with a side of fried chicken. Talk about multitasking. A failed U-turn, an unlicensed driver, and some good old L fried chicken munching. Oh, and let's not forget, the man couldn't even pass the sobriety test. Honestly, I've seen better performances at the local karaoke bar. This is going to be a tough one for him to squirm out of.
The law enforcement officer contacted the defendant and observed him to be eating fried chicken. The law enforcement officer asked the defendant why he didn't lower the window, and the defendant stated he didn't have any food and continued to eat. The law enforcement officer observed the defendant did not have a driver's license and was incoherent when asked to provide his name and date of birth. Law enforcement eventually identified the defendant by name and date of birth. The defendant continued to state, "I don't have anything unquestioned about his whereabouts," and standardized field sobriety tests were conducted. The officer observed 2 out of 6 clues in the HGN, 5 out of 8 on the walk and turn, and 0 out of 4 on the one-leg stand. Due to the defendant, 0 out of 4 on the one-leg stand due to the defendant being unable to perform the test. The law enforcement officer noted that on the walk and turn, the defendant did not turn around. He stayed still for approximately 30 seconds. The law enforcement officer explained the one-leg stand, and after the instructions, the defendant began performing the walk and turn. This occurrence happened again after the law enforcement officer tried to explain the one-leg stand another time. The law enforcement officer observed 2 unopened 6-packs of alcoholic beverages that were cold to the touch, and observed an empty fuzzball and a 24-ounce can of Modelo beer and an empty Twisted Tea alcoholic beverage. The defendant refused both breath and blood. A blood warrant was signed and executed.
Mr. Juarez, I'm going to find that there's enough probable cause to go forward with your case. You said he doesn't have a license, right?
There's a number here, Your Honor. I'm not unsure if that meant that he did not have the license at the time.
I don't mind running it, please.
Yes, Judge. Your Honor, he does have an eligible driver's license.
I'm ordering you not to consume alcohol, illegal drugs, or unprescribed controlled medication. I've ordered you not to pick up any new cases, not to violate conditions of bond, and you have repeatedly done that. As a result, I am now revoking your bond on the first case, and you will go to jail today. And I'm going to tell you, you violate conditions again, I'm going to make the bond so high your head will be spinning. Do you understand? You're not to consume alcohol or illegal drugs, and I will put a scram on your ankle so I know that you're not consuming. Do you understand?
Your Honor, if I may,
Yes, sir.
on the first case, the court previously was testing Mr. Warwares 2 times a week, and he was doing pretty good on that for an extended period of time. In lieu of revoking his bond, would the court consider going back to bi-weekly testing?
Yeah. He picked up a serious case. He has alcohol in the car. I mean, he's allegedly consuming while he's driving, you know? I would figure that it's damn elementary that you're not to have alcohol in the car while you are driving. And there are multiple open containers, cold to the touch. No, I have to show you that we mean business. And me letting you go again when you have multiple violations, it's not going to happen. You go to jail. I don't know what we're going to do when he bonds out, Michael, as far as testing now. I don't know. But
I understand, Judge.
I'm going to order him not.